Namaste and greetings. I am Chandra, advocate practicing for more than 3 decades. I am also active in the concept of alternative dispute redressal mechanism. COVID-19 situation has thrown several challenges now. As civil practitioners, now we have to look at different alternatives to see that we are able to move on in life. Keeping this in mind, let me now discuss about the various alternatives which are available to us in the field of law, particularly in the civil law, to see that our clients do get quicker and effective justice. One of the mechanisms could be neutral evaluation. What is neutral evaluation? As the very word suggests, it's an evaluation by a person who is neutral to both the parties. It is not you who is representing one of the parties. It is not the other advocate who is representing the other party. The neutral person is one who could be a senior advocate who is standing in the bar, who could be an advocate who is an expert in the field of the matter. It could be a retired judge, or it could be anybody. If it is a technical matter, it's something to do with the technical subject involved. The case which is with you, maybe pending in the court or to be filed by you, can be referred to him, and by consent of both the parties, that is to say you and your opponent, both can simultaneously approach the neutral third person whom you have identified as an evaluator. And that person, the evaluator, gets all the records, gets time to go through the entire documents. If need be, he also gets all the clarifications required from you, maybe the necessary documents, invoices, or some technical material which is required. The neutral person will give his non-binding opinion, the merits and demerits of the case according to him. Please note, it is not binding on you because it is only his opinion, and it is for the two of you to decide whether you would like to go by his opinion, honor his opinion, and probably take the next call of taking a decision whether to agree on a settlement or agree to disagree and continue the court case. That neutral person's opinion is being non-binding. He may be saying that you have only 30% chance, whereas your opposite has a 70% chance of winning the case or losing the case. Based on that, you probably also can request him to take the next step of continuing the process of mediation, where he tries to help both the parties in arriving at some sort of a consensus in finding a solution. A matter of recovery of money. Probably based on his opinion, you can always arrive as to what could be the way you can resolve it, by you taking certain amount and giving up some other amount, so that both of you are in a win-win situation. Now it has its own advantages. Firstly, the person whom you have chosen is not anybody who is interested in the matter. He has no right interest in the decision which you take. So he is a neutral third party. He is also a subject expert, and both of you have regard for him. Therefore, you both have, by jointly you have approached him and you are seeking his opinion. So you are moving from the adversarial process to a consensual process, where both of you will know the reality of the matter and you will be able to take a future decision. The flexibility available to you is that you need not even agree. If you want to, you can always arrive at a settlement between the two of you, sign the settlement, may be reported to the court under Order 23 Rule 3 saying that you are amicably settled the matter out of court. Now the next question is, which are the cases which are more appropriate for referring to neutral evaluation? I feel most of these commercial matters or matters pertaining to declaration, account, bank disputes where interest is a subject matter of the dispute, this could be ideal for neutral evaluation. Usually if the parties are related by commerce or by business, it is easier for them to take an opinion. One thing very important about the mechanism is every case doesn't require an adjudication. That is to say, every case which is in the court doesn't require a judgment by a court where your rights and obligations have to be decided by a court and the outcome has to be given by the judge. In some cases, some of the parties want an opinion as to where they stand, whether they have a merit. If so, to the extent, what is the extent? If they do not have the merit, then what is the best remedy available, or to have a way out from the case? So in such cases, neutral evaluation is the best remedy. While bringing major amendments to the Code of Civil Procedure 1908, the Parliament in the year 2002 reinserted Section 89 CPC, recognizing 5 different mechanisms as alternative to the existing judicial disposal system. Lok Adalats under the Legal Services Authorities Act 1987 is one of the alternatives recognized therein. Permanent Lok Adalats are constituted in every district and taluka centers as a pre-litigation center where the parties having disputes under public utility services recognized therein can directly approach the Permanent Lok Adalat for remedy. This is separate from Lok Adalats. Lok Adalats are meant for only the existing cases which are pending in the courts, whereas Permanent Lok Adalat are meant for new cases which are to be filed as pre-litigation. Section 138 Negotiable Instrument Act and motor compensation cases and such other disputes like suit for compensation, recovery, these are easily settled in Lok Adalats, and in fact Lok Adalats are doing a wonderful job. Now we will move to part 2 and discuss about the other alternatives which are available. Thank you very much.